Resurgent India Knowledge Series presents live webinar on the challenge faced by micro enterprises in initiating arbitration. Moderator Mr. Sudhir Chandi, Director, Resurgent India Limited. Eminent speakers Mr. Madhup Singhal, Advocate, Business and Commercial, Supreme Court of India. Dr. Swati Jindal, Advocate on Record, Supreme Court of India. Mr. Sanjay Kumar Chhetri, Advocate, Resurgent Legal LLP.
Where you are on mute, sir.
Sorry. Yeah. So, welcome, friends. I welcome you. Good evening, friends. I welcome you all for today's webinar on the challenges faced by micro enterprises in initiating arbitration. As we all know that MSMEs play a vital role in Indian economy, yet they face significant hurdles when it comes to resolving commercial disputes. Under MSMED Act, the Micro and Small Enterprises Facilitation Council is empowered to resolve such disputes through arbitration, and the Act authorizes the Council to act as an arbitrator or to appoint one, ensuring a structured mechanism for redressal. However, despite the statutory backing, initiating and navigating the arbitration process remains a challenge for many micro enterprises. One of the primary issues is the lack of awareness among MSEs regarding the rights under MSMED Act, including the provision of arbitration. This often results in prolonged delays in claiming dues and over-reliance on informal or ineffective means of resolution. Additionally, the cost associated with arbitration, both perceived as well as real, can be burdensome for small enterprises operating on limited margins. Even when arbitration is pursued, enforcement of awards remains a concern, especially in cases involving larger corporations or government entities which has, good legal muscle power with them. The effectiveness of the current redressal mechanism is also limited by procedural delays. So if we look at the data, MSME Samadhan portal, out of 90,000 applications filed, payments worth 21,108 crore remain pending. Of these, 40,000 applications amounting to roughly 14,000 crore have been formally taken up by MSEFC. However, only about 19% of the total cases have been disposed of, highlighting a considerable backlog in the system. Notably, the state government and the central public sector undertakings constitute a significant portion of total pending dues, with the highest being 2,170 from the state governments alone. The MSMED Act clearly stipulates that buyers must make payment to MSEs within 45 days, and if they fail to do so, they are liable to pay compound interest 3 times the prevailing bank loan rate on any delayed amount. Yet compliance with this provision is very, very inconsistent, and enforcement mechanisms really need some strengthening because MSEs are not getting their payment on time. Now, this webinar will delve into structural, procedural and legal challenges faced by micro enterprises in initiating arbitration, while exploring potential reforms to make the process more accessible, efficient, and effective for the sector. So today's discussions point will be regarding the delay in constitution of arbitral tribunal by MSMEs, time taken by tribunals to grant relief, and also the role of facilitation council in the MSME sector. So I'll just introduce our distinguished panelist, Mr. Sanjay Kumar Chhetri, Advocate. He is a seasoned legal professional and part of Resurgent Legal LLP, which is a premier full services law firm established by accomplished attorneys and extensive experience in advising clients across diverse industries. It has a dedicated team of legal experts, specializes in providing comprehensive, timely, and tailored solutions to complex legal and regulatory challenges. Now, Mr. Chetri, with comprehensive expertise in arbitration and litigation across a wide array of judicial forms, including civil courts, criminal courts, consumer courts, High Court, Supreme Court of India, NGT, NCLT, NCLAT, National Consumer Dispute Redressal Commission, and arbitral tribunals. Presently, he is associated with Resurgent Legal, and previously he was a senior associate with George Thomas and Company and Singhania and Partners, as a partner at Francis and Company as well. As a distinguished member of Delhi High Court Bar Association and Supreme Court Bar Association, Mr. Chetri specializes in arbitration and litigation, with a focus on complex matters involving NHAI, railway contracts, FIDIC, EPC, BOT, BOOT, HAM projects. Renowned for his strategic acumen, he has successfully represented clients in high stakes cases, securing favorable outcomes in significant arbitration appointments. Then we have Mr. Madhub Singhal, Business and Commercial Supreme Court Advocate. He is a seasoned advocate with over 22 years of diverse legal experience, and he began his career with Gagrath and Company and spent 6 years working with leading law firms before transitioning into corporate sector. During his 9-year tenure in corporate world, he held key legal positions at prominent organizations such as Vedanta, GMR Energy, Monet Group, and Jubilant Energy. With strong foundation in both litigation and corporate law, Mr. Singhal went on to establish his own full service law firm, MSA Legal. Known for his business oriented and solution driven approach, he is widely recognized for providing legal advice that aligns revenue generation and strategic growth. Mr. Singhal also specializes in MSME arbitration matters, making him a trusted advisor for resolving complex commercial disputes. I welcome Dr. Swati Jindal. She is advocate on record with Supreme Court of India, and she is an esteemed advocate on record, practicing before Supreme Court of India, Delhi High Court, and various district courts and tribunals in Delhi. Holding a doctorate in criminal law, she serves as a legal member in the Internal Complaints Committee of Government Institutions. Dr. Jindal has been a visiting lecturer in Law Center 1, Faculty of Law, University of Delhi, and is a prolific writer contributing articles on legal issues to reputed journals and magazines. She has authored books on legal matters with a particular focus on women-related issues, like sexual harassment of women at workplace, and a chapter in engendering women in India, and works on sexual harassment of women at workplace. Passionate about women's empowerment, she champions confidence building and leadership development, firmly believing the transformative power of women, supporting and uplifting one another for holistic progress. Now, with this introduction, I start today's webinar, and I'll start by ladies first. So I'll ask Dr. Swati Jindal your first question. The MSME Development Act prescribes 45-day time period for payment to the buyer that has been unable to improve their liquidity. But despite these facts, ma'am, we have noticed that many a times buyers neglects to make the payment. Is it due to lack of awareness, or there could be some other reasons?
See, Mr. Chandi, the problem is India, with its unique culture, MSME is such a good thing to develop the economy as a whole, because we have so many units that can be classified under MSME. Now, despite this 45-day period, the resolution of the payment is not taking place within that time frame. There are multiple reasons for that. The first one, I feel, apart from what you pointed out, which is the lack of awareness on the part of both the parties, the buyer is also not aware that the MSMED Act says that, 45 days is the time period given. And even the seller is not aware that, well, this is my right. You are only able to enforce your right when you're aware of your power. Even the seller is not aware. Let us for a moment feel or believe that the seller in fact knows that, the payment must come to him within a period of 45 days as per the MSMED Act. Now, the problem here is that the buyers are so strong. Everybody wants to sell their product. There are so many sellers and not enough buyers. So because the bargaining power of the buyer is just so strong that generally what happens is this 45-day on paper period translates into the usual 60 to 90-day cycle. Then, like I said, even if you look into the penalty that is imposed, suppose even both the parties are aware that the payment should have been done within 45, it is not done. What is the max that could happen? A penalty will be imposed. There is no arrest provision, there is no attachment provision, at the most an inflated interest. Now, whether you will be able to get that from the other side or not, at the end of the day, when the payment comes to you, you are like, please give me the principal, forget the interest. The seller is so constrained. Even if, I'm not saying that the government or the legislature is not making any efforts. They have tied MSMED Act with the Income Tax Act. And I think that's a step in the right direction. By tying the two together, you're kind of surrounding the defaulter from all sides and ensuring that, because of added penalties, even a higher income tax liability under the Income Tax Act, maybe the buyer would be encouraged to pay his dues on time. But how will that happen? Because the entire process has been made so complex and burdensome that the parties are unable to understand the linkage between the two. So these complexities, the financial constraints, and primarily the power imbalance that exists. Now, over and above all these constraints, we also have the weak enforcement mechanism. Now, if you see what exactly do the MSMEs have in their, in their purview, they have this MSME Facilitation Council, which is, I would say, not a very strong, enforcement agency. At the most, they can call you for the mandatory conciliation, mediation. And then after that, if it fails, then you go to arbitration. Then we suffer from other problems of, who will be the arbitrator, how it is to be appointed. And then finally, when the award comes, you again go in a 34. So all these things, they lack of any penalty beyond the specified interest. All these things, they sort of encourage the other side to default, I would say.
Right, said, but I think there is more strengthening from the government side needs to be required so
Yes.
that there is a balance between MSME dealing with large corporates, how that can be done. And yes, of course, awareness also helps in those things. Ma'am, also it is noticed that technical or engineering disputes are also raised by the MSMEs. In this regard, how helpful is the Micro and Small Enterprises Facilitation Council in resolving dispute through conciliation?
So what happens is they have this facilitation council. See, what they have done is it's a step in the right direction, I would say, because they play a crucial role in resolving all these technical and engineering disputes. They would first put the matter, like we all know, for conciliation. There is a particular time limit. If the conciliation can happen within that time, it is good. Well, as per the statistics, it shows that at least 20% of the matters are conciliated. So I wouldn't say that it's a bad record, a bad statistic. Now, if suppose the conciliation fails, then the matter goes ahead for arbitration, and then you go through the whole conundrum of how the arbitrator, like I said, is going to be appointed, whether any other party is going to be satisfied with the award or not, whether they're going to take it ahead. Now, one good thing with the facilitation council is, as far as these technical aspects and the engineering aspects are concerned, is that just like let's take an example from the tribunals. See, in most of the tribunals, for example, in Central Administrative Tribunal, you have matters pertaining to service law. So they have also an administrative member over there. If you look at the consumer forums, you have administrative members. So their presence does help in sorting out the matter because they have an idea of how the things move in the service sector. So similarly, most of the MSME disputes also come out from technical issues or engineering faults. One of the parties would say this could not have been done because this was done. So that becomes, there you need a technical expert to handle that kind of a situation. So as far as these facilitation council, their composition is concerned, we do have technical members and engineers. So I think that goes a long way in, taking the dispute in the right perspective, because the buyers don't feel that they're banging their head against a wall and what will these people understand. They don't know what problems we are facing, because at the end of the day they have engineers and technical members sitting over there. So I think that is a good step in the right direction.
Okay, ma'am. Ma'am, on failure of conciliation, the MSME Facilitation Council seeks the assistance of institution for conducting arbitration. Can you please explain the procedure involved in appointment of arbitrator?
So what happens is that as far as the MSMED Act, there is the first round which is pertaining to conciliation that has to be, crossed. Now, if that point has failed, like I said, 20% of the matters do get conciliated. So if your matter happens to be one of that, well, I think you should take it and run. But suppose that does not happen, then in that case, there is a mandate of arbitration. Now, when that happens, it is the council's decision, on the forum of arbitration. Sometimes the council may decide, the facilitation council may decide to conduct the arbitration itself. Sometimes what they do is they, looking at the matter or maybe the interest of the parties, they decide to refer it to another institution or an ADR center like the one we have, the DIAC, the Delhi High Court Arbitration Center, so on and so forth. Then there are other, arbitration centers also. Your dispute might be referred to that. So if the council chooses not to conduct it itself, it issues a written reference to a designated alternate dispute resolution institution. Now, the important thing is here that that particular institution where they refer the matter, it must be recognized and it should be competent under the Arbitration and Conciliation Act. If that is not so, then the entire process goes down the drain. Now, once that institution, that matter has been referred to an institution, it will appoint one or more arbitrators, basically depending upon the nature of the dispute, whether they require any technical expertise, any prescribed procedure has been mentioned under its rules. So mostly it so happens that, looking at the amount involved, generally a sole arbitrator is generally appointed. And then there are the options that, there will be various choices available or a list available, and then the parties on mutual consent can get a sole arbitrator appointed.
Thank you, ma'am. I'll come back to you, ma'am, again. Meanwhile, I'll come to Mr. Madhub Singhal. Sir, according to you, how far Micro and Small Enterprise Facilitation Council has been successful in resolving the MSME disputes, especially in Delhi NCR region where we are sitting right now? You are on mute, sir. Madhub ji, आप mute पर हैं?
Oh, sorry. Thank you, Mr. Chandy, for inviting me for this webinar. That's very pertaining question because yes, Act provides facilitation council to MSME, but what I'm experiencing and what I'm observing since last many years that councils are not very much effective in resolving the disputes. If you talk about the Delhi NCR, if I talk about the statistics, which I mentioned to recently to Mr. Manjhi, the minister for MSME, central minister. So in total application filed before the Delhi Council are around 28,000. And only out of 28,000, 8,500 applications are disposed of. So more than pendency of 16,000 applications. So this is the MSME work, the main dispute revolves around the liquidity. Whenever there is and any organization fails because of lack of liquidity. So whenever there is a dispute that payment has not been made by the buyer within 45 days, people approach there, and if the matter will take 4 to 5 years, then it's very difficult to survive MSME in this given scenario. So we work almost in all MSME sectors everywhere in the, especially UP, Punjab, Haryana, etc. But the position everywhere is more or less same. There are some matters which are pending last 4 to 5 years.
That's a very pathetic.
It's very pathetic. Though the government is giving so much emphasis on MSME, but I don't think MSME Council are working effectively in any of the states.
I think then, some reforms are really needed,
Sir, yes, absolutely, sir.
Whatever has been done, that has been done in good faith, but still that's not good enough for
that's not good enough.
It's not helping. Right? It is definitely not helping. Yes.
Practical scenario this.
Yes, so if the Indian MSMEs have to come up really well, then something more needs to be done. Otherwise, they are being eaten by the larger corporates.
Absolutely, absolutely. And MSME is the bone of Indian economy,
Absolutely, they are the backbone. Yes.
the
So
backbone
I
of
think
the Indian
government is
economy.
aware of these things and they are trying to do their level best, whatever is possible. And surely we'll see some more reforms coming, which
Hmm.
would help, MSMEs, fight with this liquidity concerns and all. So maybe,
Yes.
that is up there. So, what are the challenges really MSMEs faced when referring a dispute to Facilitation Council?
Mr. Chandida, as you mentioned yourself, that the lack of awareness is the first basic thing. There are a number of MSMEs which knows that yes, if I will get registered in MSME, I will get number of benefits. But what exact benefit they will get and what they are right under MSME, there are uh, very less awareness among people. So this is the foremost thing, foremost challenge which a MSME face. Whenever there is a non-payment of the amount, basically MSME face generally one or two kind of disputes. And the out one is the major concern is the payment. When they don't receive the payment, they generally approach to some lawyer or some consultant. They generally say file a suit, civil suit, recovery suit. They are not aware about the felicitation that being an MSME, you are at times it happens that people themselves don't tell to the person that I am a MSME. Later on, they say that I am a MSME also. So it is.
So, they need to mention that they are MSME on their invoice.
Yes, it can be mentioned because whenever we work the corporate generally take a undertaking that whether you fall under MSME or not.
Yeah, big corporates do
Big
that, but
corporates, big
I don't
corporates,
think everybody is doing. I think
but
MNCs,
yes,
yeah.
in general practice, except big corporates, no one does this.
Yes, somebody with a good corporate governance, they are doing it. And I have also seen sometimes, that because of this 45 days, clause,
Hmm.
sometimes they also force the MSME to, revise the invoice again.
Yes.
They refuse to accept the earlier invoice. And whenever they have to make the payment, they say, now you raise an invoice.
Yes, yes. Now, yes, first they supply, then even if then suppose that they got the, even if they have the suppose knowledge of that, yes, we have to file an MSME. When they move to the MSME council, there again number of dispute, number of challenges they have to face, like jurisdiction
Yes,
conflicts. Always buyer says, no, 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 you are not. This is not the correct MSME.
yes, yes.
Challenge remains the jurisdiction. No, you. Though this position has been cleared with the Supreme by the Supreme Court and the Act itself, that where the supplier is, the jurisdiction is with that. After that, delay in formation of arbitral tribunal, again a big first matter will roam around the mediation. Number of days went into mediation, then matter is referred to arbitration, and there is no time bound. Earlier there was a 18.5 wherein a dispute has to be resolved within 90 days. Now, after the 2023 Mediation Act amendment, that has gone. So that is again a big challenge for the MSME.
Right. Okay, coming to Mr. Sanjay. Mr. Chetri, under what circumstances the client from MSME approaches you for your guidance?
In most of the times, it seems simply for delayed payment, they used to come approaches us. The many grievance is there, they are not paid on time, then still paid 48 days. That is one thing. And in some of the cases seen, there are disputes with the parties with regard to when one party supplies, in case of equipment, design not as per specification. The buyer says, I have not received a specification. He says, I supplied a specific. That dispute remains. So in that case, also many a times the client approaches us for MSME, approaching MSME facility center, and for compliance, for documentation, so that uh, they can acquaint themselves prior to approaching MSME facility councils.
Coming to Dr. Swati, ma'am, talking about the MSME Samadhan portal, it shows a significant blockage in resolving dispute. What, according to you, has been the reason for this significant blockage?
See, what has happened is it was launched primarily to provide a digital platform for all the MSMEs to file delayed payment complaints under the Act. Now, that despite the good intention behind making the whole process, small businesses and the system, they suffer from many blockages. The first and foremost is, of course, the cumbersome process in itself. So many documents are, required. They must submit a purchase order, invoice, delivery challans, payment reminders, so on and so forth. So for many small businesses, especially those in non-formalized sector, this documentation is either missing. So many things in India are still happening on Meri Zuban. So no written proof as such is there with small business sectors. They say that keh to diya, ho jayega. And like I said, in the improper power dynamics that we have here, generally the weaker party says, "Acha ji, aap keh rahe hain, ho hi jayega." So many missing, incomplete, or non-digitized documents, so to say. For a moment, let us assume that, okay, somebody was very, very competent and they do have those documentations. They don't have enough manpower to upload them or the technological know-how. So number of offices, technical staff to process all these claims, it's very highly inadequate. So maybe we have over 1 lakh applications that are still pending. Rising monthly filings, portals, they lack the human infrastructure to scrutinize, validate. They are already, if you see the councils, they're already overburdened. And many states, they even lack fully functional councils. Then, like, Mr. Singhal said that very, very poor case disposal we have. Only 20% cases have been resolved by mutual settlement. More than one third are still unreviewed by the officers. Stagnant because of, well, red tapeism, bureaucratic delays. Then we have limited awareness, primarily, no awareness amongst MSMEs. Many small sector enterprises are unaware of the complete process of filing a complaint. So maybe we can have some sort of a demo video that can help them to, some sort of, if you're stuck here, then this is what you do. Even if they start using the digitized process, if they get stuck on one of the points or one of the steps, then the process remains unresolved forever. So we need a proper training on how to use that portal itself, how to give proper documentation. We need the legal understanding, which leads to, avoidance of incorrect filing of applications or rejection of cases only on technical grounds. Then we have the inefficiencies in the dispute resolution mechanism itself. So let's assume for a moment that a complaint is finally forwarded to the council. Now, even after that, there are so many long hearing gaps, there are adjournments, and there are lack of technical adjudicators. Like Mr. Singhal again said that, the time limit of 90 days has gone now. So people are basically sitting and the councils are telling them, nahi, abhi conciliation ka process pura nahi hua hai. So once that delay of the arbitral center will come later on, we are finding a huge delays and gaps in the mediation only. So these things, they need to be taken care of. We need better manpower. We need more digital literacy. We need a better monitoring mechanism. We need proper legal support cells at the state level. And for the bigger states, we need them at various, for example, districts maybe. So many facilitation, these councils are there. They're giving one council per state. It's not. Can you imagine a state as huge as UP, Maharashtra, surviving on, only one such council? We don't have
They're
any.
as big as country, UP is as big as a country, bigger than many
Yes.
countries itself.
Yes,
Yes, absolutely.
definitely. So that is what we need to do. I mean, even though we have started, I mean, if you want to feed an army and if you come out with one packet of chips, that will not be enough. So the intention is there, but the means are not, I believe.
Yes. I think there is an intention is there, but again, the 90-day period window going off, I think it's a
Yeah,
regressive.
it has just opened up a Pandora's box, and now we are sitting here feeling that, good days will come, but we all know that they're quite late already.
That's right. Okay, ma'am. So how much time generally, this arbitral tribunal takes in passing a arbitral award?
See, we have, as far as the Arbitration and Conciliation Act is there, it's been there for us for a while, thankfully. So things are quite concretized. We have a lot of judicial activism also in the field. Section 29 clearly talks about a time-bound period. After the amendment, now we have, a period of 12 months after the completion of pleadings. So that makes it 6 months for completion of pleadings and 12 months thereafter. a roundabout period of 18 months, which is extendable by another 6 months at the with the permission of the court. So we are talking about more or less 18 plus 6 months max to max.
And all cases generally, gets
In
about.
all cases, generally now it is very time bound. And of course, if you want to extend it, it is always subject to the permission of the court, and then it might or might not come. But then again, a problem is that one party might feel aggrieved if proper permission is not given. So, but then, like I said, when you are in an adversarial system, one party will always be unhappy. So, but
That's right, of course.
we have tried to limit the time in arbitration, no doubt, but that process also fails when somebody goes in a section 34 opposition. So we are back to square one in that case. After having spent so much on the arbitrator's fees, we are back to square one with an unresolved problem.
That's right. That's right. Ma'am, please enlighten us on the procedure for setting aside the arbitral and arbitral award passed under the Act.
Well, like all other procedures, for an arbitral award, it needs to be challenged. It needs to be opposed under Section 34 of the Arbitration Act. The only difference here is that Section 19 of the MSMED Act provides for a mandatory deposit of 75% in the court before you actually go and oppose an award. I feel that is a very good, it's a step in the right direction because, it puts some pressure on the buyer. So to say, or whoever who has defaulted. And they nonetheless, they would end up paying 75%, which is a huge amount in the court. So some of them feel that they might as well pay to the other side and get, put a quietus to the list altogether. So that pre-deposit is mandatory and not discretionary. So that I feel is a very good step, and deposit must be made before the court can entertain even the application. So even if you're going in a Section 34 application, you must go with clean hands after having deposited the 75% already. So the court may allow the amount to be deposited in installments if you show adequate reasons. And the purpose, like I said, is to protect the MSMEs from delayed payments. Like I said, Mr. Chandy, the intention is there. And like all good things, this will also take some time. But my only grievance is with the amount of time it is taking. And maybe if you could just step up the infrastructure a little bit, things would be more fast-paced, and people would not feel so disheartened, because we need to really. India is we all portray it as a superpower and an upcoming nation. Oh my God, recession is affecting everybody, but look at us Indians raring to go. But the problem is there that you pump us up, we are raring to go, but suddenly you pull brakes. So the entire enthusiasm fizzles out. So when you are creating this infrastructure and when you're saying that we will give you the ease of doing business, there is no need to put so many roadblocks of various documentations, because for so long, India has been a nation where, things do actually work well on the word of mouth. So we need to, instead of totally killing our own root culture and trying to ape the West unnecessarily, we are killing the good things that we had in our culture already that were more suited to us. So I think we should, like the age-old culture of hundis and this and that. I think that it is time now that we should work on our ancient thought process and rely more on that.
Right, ma'am. I have one more question from you, but I'll just come back to you. I know you have to leave early. Don't worry, I'll free you before time. I'll just come to Madhubji. As you are aware that on receipt of reference from Micro and Small Enterprise Facilitation Council conducts a conciliation in the matter, how far the Micro and Small Enterprise Facilitation Council succeeds in conducting conciliation?
It's again very important questions, because according to me, in very few matters, maybe 10 to 20% matters, MSME succeed in the conciliation. The reason, there are a number of reasons. It's my personal opinion that mediation or conciliation, earlier it was conciliation, now it's a mediation. It can be succeed only when the mediator or conciliator who is mediating or conciliating the matter should be aware of the matter in full, should understand the technicalities and all the things about the matter. Then only he can give the correct perspective to both the parties, that this is the picture, this is the correct technical and financial picture, and it's better to go into settlement. If you see the construction of constitution of most of the council, there are lack of technical members. They may be expert of one or two things, but there are a variety of disputes. So it's very difficult for the council to be engaged technically or financially, so that they can correctly inform the parties that this is the merit and demerits of the matter. So you should do this. They make the effort, but mostly in the cases, after one or two hearing, matter goes to the arbitration. They refer the matter to the arbitration.
But do you think 20% is good enough rate? Can we compare
20%,
it with some?
I have not checked the correct statistics, but I don't think it's more than 10 to 20% where
Okay.
the matter got settled, because every time one of the party wants to linger on the matter. That is the beauty of litigation, that one party always wants to delay the matter.
Yeah, one party will always be unhappy, right? Like Swati ma'am says, yes, in a court of law, one party will always be unhappy. Yeah. Okay, ma'am, coming back to you for your last question. How are the central government, granting the funds for this purpose of this act? How it is happening?
If you look at the statutory framework, section 13 and 14 of the MSMED Act, they talk about how the funds and the grants are going to be taken by the central government. Section 13, it talks about the central government, by after due appropriation by the parliament, they may credit certain funds to the established, various funds established under the act. Now, these funds are provided as the government considers necessary for fulfilling the objective of the act. The government has set down certain parameters. The government knows that all these things will take certain, amount to be expended. So as per that, whatever funds are set aside, central government is going to obtain it. If you talk about section 14, then there are, it talks about how these funds are going to be utilized. Section 12 primarily talks about how these funds will be created in the first place. So there may be various, notifications by the government where they create certain funds. And as per grants that are given from the central government under section 13, these funds will be created. We have so many funds like the Prime Minister Employment Generation Program, Credit Linked Capital Subsidy Scheme. Then we have the Credit Guarantee Fund Trust for MSMEs. We have the MSE Cluster Development Program. We have the Interest Subvention Scheme for Incremental Credit. So all these funds, see, because at the end of the day, money is the bottom line. Until and unless you have the money, you will not be able to generate anything. I was talking about an enhanced infrastructure. Well, it does not materialize out of thin air. It needs a lot of generation of funds and also expenditure. So for all these things, various provisions have been made. The problem here is whether they are being routed through the right channels and whether they are being utilized in the correct manner. And if there is any leakage in the middle, which is always a problem with, any country for that.
Right, ma'am. Before going, ma'am, any advice you want to give to the MSMEs, how they should approach or what should be?
Well, I would, like I always say, hang in there and keep the Josh high.
ठीक है, ma'am. Thank you so much.
All right. Thank you so much.
Coming back to Mr. Chetri. Sir, in what ways, Micro and Small Enterprise Facilitation Council falls short of addressing the dispute? As we already know, it is falling short, but in what ways it is falling short?
Yeah, as rightly said by both the speakers, the problem with MSME is that it's not structured in all the states. Now, we have been talking on Delhi NCR. We find I had last experience appearing in Meerut. Meerut, they have their own facility center. They come with 3 or 5 people, they form a gang. But when somebody, if he appear on the behalf of the buyer, then they will force him to accept whatever he has said. Now, in this process, we are not getting the exit relief. Ultimately, what happens? Ultimately, it delays the proceedings. They are not familiar with, I feel, familiar with the law. They go with their own because the bureaucrats are there. So ultimately, as I said, the proceedings are delayed. Now in MSME, first there's conciliation, you have to go to conciliation. Other part doesn't want to win conciliation, but still he will participate in the conciliation process, knowing very well that ultimately he is not going to admit it. He will delay it. And ultimately, again, then the Facility Council will appoint an arbitrator. then they also delay. Ultimately, the purpose MSME has defeated as on date. Because MSME is why the act is come out to help out the small, micro small enterprise. Because of this act, the 40 days period is there. When you challenge the deposit, you have to deposit 75% of the award amount. So the provision of made in the act to help out the MSME. But in the long run, the bigger corporates are getting advantage of by lingering the litigations. This is one difficulty in that we face. And there is also lack of uniformity in all the MSMEs. The MSME in Meredith are working in their own tandem. MSME Panchkula is working in their own way. So this uniformity is not there, resulting in delayed appointment arbitrage also.
Okay, right. So, what is your advice to MSIs prior to, referring the dispute to the facilitation council?
No,
What
first of all, I will advise the client to first of all, that as rightly said, madam, sometime back, it comprises a lot of documentation. So they don't have that particular skill to create the data for prior to initiating, approaching facility council. So that documentation part has to be there. And that part, what I advise most of the client that you go for conciliation, because ultimately you are small man, big people clients are there. Conciliation, whatever they get, XY amount, you take the amount and walk out. Otherwise, this mediation, that arbitrary award 34, it will not help the small people, the micro enterprises. It's only nowadays it's more advantage for the bigger people because they have long waiting period. They have time, they have funds, they can wait longer period. But by the time the MSME, if it's liquidity crisis, and they dry with the funds. So I advise them go for conciliation and take out the money and be happy.
Okay. So, Mr. Madhup, what is the procedure for constitution of arbitral tribunal by MSME Facilitation Council on failure of conciliation?
So now the process is once there is a mediation, whenever a reference is made, council take the matter to the mediation. Earlier it was conciliation, now it's a mediation. The mediation fails, there is as per section 18(4), the arbitral tribunal is either council can himself arbitrate the matter. They have power that they can also themselves handle the conduct the arbitration in their own. Meerut council generally doing the same thing. Otherwise, they can appoint, they can refer the matter to any arbitration center which is recognized by Arbitration Act. That's a simple procedure, sir. And then once the matter is referred to the Delhi International Arbitration Center or any center, so then arbitration center rule will be applied. Whatever the act says, Arbitration Act, that is fully applicable.
Okay, you took the example of Meerut. So can you please share your experience with the MSFEFC Meerut? Any
Sir,
experience?
experience is, I think there is no difference between Council of Meerut, Delhi, Panchkula, Mohali. Every work is going on everywhere, but the speed is really very slow. Clarity is very less. Experts are not there because in Meerut Council, number of dispute from Noida referred, and Noida is a big hub for now industry. So different kind of disputes are there, and the council doesn't have that kind of expertise that they can resolve the dispute in a good manner. Besides that, there is no judicial member, so they don't understand at times the implications of law, which is very important. There has to be one judicial member, experienced judicial member, which can understand. And the problem with the legal system is that very few judges are there who can understand the corporate word in a correct manner. Especially in UP, in Delhi, you will find the judge who their commercial understanding is very good. But in UP, you will get very less judge. UP, Haryana, Punjab, mostly judges are well versed with the civil and criminal procedure, but not very well versed with the commercial aspects. So that is the biggest problem MSME face.
Meanwhile, I'll request the participants, if they have any questions, they can type in the Q&A box. Once this is over, I think within 5 minutes we'll wrap it up. And if you have any questions, we'll try to address those questions. So you are encouraged to ask any questions. Please use the Q&A box. So, Madhupji, can you please share your view on the recent judgment passed by the Supreme Court on Tamil Nadu Cements Corporation Limited versus MSME Facilitation Council?
Okay, yes, it's a very important judgment. In fact, we are handling one matter in Meerut wherein against the MSME got the award in our favor, complete award, more than around 7 crores award. But the other party filed a writ petition before the Allahabad High Court. Though as on date they could not get the stay, but yes, they have moved Allahabad High Court on the ground that yes, we have to on number of grounds which are not tenable. But in that case, the main ground was the whether in that case what happened, the MSME, the company, our client got registered MSME later on, and they executed contract before the registration under MSME. So on that ground, they moved to Allahabad High Court. So, but in this issue, the main in the Tamil Nadu one, generally most of the courts used to give indulgence in the writ petition, because writ petition is the medium wherein everyone goes and sees that it's my fundamental rights are being infringed. So if I give the brief background of this matter, the main issue was whether a company can file a writ petition under Article 226 of the Constitution under an order against the MSME order. So earlier the position was that some court said that yes, there is an alternative remedy, because against the award there is a Section 34 Arbitration Act, and is the defined principle of number of judgments. Supreme Court has said that if there is an alternate remedy, it will not lie. But still, in some circumstances, courts have power to entertain the writs. So similar thing happening in the matters. So now this issue, whether what has happened, the court has referred this matter to the larger bench to decide this issue. Whether this writ is lie against the order or not, because controversial issues, number of writ petitions are pending before number of high courts, because instead of using remedy under 34, and the main issue why people don't go against the award in 34, because the deposition of 75% amount, which is the prior, and in number of matters, time period is also 120 days, strictly 90 plus 30 days under Section 34. So people generally miss that time period also. So that's why number of writ petitions are pending against the MSME award, against the Facilitation Council order. So that's why Supreme Court referred this matter to the larger bench. And in other matter, whether the MSME benefits are available to the MSME even if the contract is executed before the registration of MSME, has also been referred to the larger bench.
Okay.
In the NBCC judgment, NBCC versus the state of I think it's NBCC versus state of Bengal judgment. So these two, once the order of Supreme Court will come, I think MSME should get big respite after this thing.
Yes, we hope for the best.
Yes, sir.
Yeah. So Sanjay ji, what are the challenges you face when you pursue your claim before the arbitrator appointed under the Act?
So when I appear for the MSME, the main problem which I face is because MSME as a counsel in MSME they don't get good counsel. I've seen in my experience. Now, in the other party come with the big law firms, the big law firm, they will they will dilute the issue. They'll take out 3 or 4 issues. They will challenge every order, and ultimately they will delay the procedure in such a way. Ultimately, poor chap feel that okay, I forget MSME, I don't want money, I want to join on a business. That is what difficult. The MSME has not helped it out in that way. And also, I rightly said the enforcement award. Now, because of the judgments come out, now every Tom Dick can go for 226. They will not file 34 because they are mandated to deposit 75% of the amount. Now, until the law is settled down, then in the meantime, the big corporates go on 226 and ultimate small people like MSME. They will not get the fund. Ultimately, one point of time, they will wind up the business. And this is a drawback which you have in this particular MSME. This is a challenge which we are facing for MSME.
Okay, I think I have no more questions for today. So if the participants have any questions, they may type in the Q&A section. I don't have any questions as yet. So we'll wait for a couple of more minutes and then we can wind up. If no more questions are coming, I think we can wind up.
But in the last, Mr. Chandi, my advice to all MSME would be that they have to keep their documentation part very solid. That's the key to everything, and to, in fact, to all the business. But if they really want to grow in the business, so their documentation part should be very strong. Then only they would be able to fight matter in the correct way.
I think, yes, that's the best
And I
advice.
see day in, day out, even the big corporates are not perfect. Except the government department, no corporate is good in maintaining the records.
And yes, and the records and the documents are the backbone of any legal case.
Yes, any legal case, any civil
Any legal, be it
matter.
arbitration or any, because this is what the judge sees, the
Absolutely.
on record. Verbal things carry no meaning.
Absolutely, sir. And my practical advice to all MSME that before filing any reference, if their documentation is not good, they should create some document, they should make some document, they should do some correspondence so that they have certain thing in their hand to fight.
And of course, whenever the disputes, starts to origin, I think from there on, at least the communication has to be in such a
Communication,
manner.
yes. In all arbitration, communication is the key.
Communication is the key. That's right.
Communication is the key.
Very good advice. I think we have a question. Madhukji, what steps can be taken to make ADR mechanism in India more efficient and time bound?
Sir, in Arbitration Act, now in MSME Act, there has to be reinforcement of the clause 18.5 again, that within 90 days, matter has to be decided. Otherwise, in arbitration, there is a time limit,
Okay.
18 months. But yes, for MSME, that provision has to be restored, that within 90 days, matter should be concluded.
And also on the payments, can things be more digitized so that, the information utility system is also used so that, the awards come pretty early? The
Yes.
documentations being digitized. So MSME is also, you are advising them to keep documents, right? But
Yes.
now they are forced to, keep documents. And they are at a place which is, accessible to everyone. Those things could also be help in terms of
Yes,
issues in
absolutely.
timely manner.
Yes. But sir, it depends on the budget of the company. There are different kind of MSMEs. So
Yeah, we can start with recommendations, recommendatory thing, then, gradually that can become mandatory.
yes.
Okay, I think we are not getting any more questions, so I'll just conclude here. Thank you so much, all the participants, for coming, and obviously, I thank all the panel members for enlightening us on their views.
Thank
Thank
you.
you so much. Bye bye. Good
Bye-bye,
evening.
sir.
Bye bye.
Bye-bye.
Jai Hind.